Welcome to this presentation. I am Ajoy Basu. In this presentation, I dwelt on certain legal terms which could form an essential part of your communication, especially when you're discussing about or reading a legal document. What these terms mean, their usage and the timely deployment are all equally important for your communication. My first sentence in this presentation is, order is manifestly clear. The word manifestly refers to something which is strikingly, palpably clear, almost as a given. I find a lot of opportunity when presenting my case before the authorities, whether in spoken or written format, to deploy the sentence. On the point of pronunciation, it is opportunity as far as UK English is concerned. In the US, you tend to use it as opportunity. So opportunity and opportunity in the US. An extremely useful sentence for you to have in your immediate orbit of recall. My next sentence is, petition is dismissed in limine with cause. In limine is of Latin origin, refers to at the start. So in the given sentence, it refers to the petition being dismissed at the start, at an early threshold, so much so that it is taken as not being worthy of consideration by the court. In legal communication, you may find many opportunities to use this term. The pronunciation here also needs to be grasped. In my next slide, my third sentence is, I submit that the present petition is defective for non-joinder of a necessary party. Non-joinder here refers to the omission to join some person as a party to a suit. In the given sentence, the word necessary implies that in the absence of such a party, no effective decree can be passed. My fourth sentence in this capsule is, only ratio decidendi is binding. Decisions per incurium and sub silentio are not binding. Obiter is not binding. Now, ratio decidendi refers to the reason or rationale for the decision. It is actually the principle which determines the judgment. Per incurium, is also Latin origin, is characterized by lack of due regard to the law or the facts. Sub silentio, also Latin origin, refers to under silence, denoting what is not expressly stated but is implied. Obiter, here in terms of pronunciation, R is silent, here refers to something said in passing. So semantically, if I look at it, the sentence says that to be binding, the decision has to have an expressed legal rationale. If the decision is taken without giving due attention or without being explicitly expressed, it is not ordinarily binding. And also the comments or observations made which are outside the decision proper, which we call the obiter, cannot be binding. My last sentence is, I must insist on receiving the money. In this sentence, insist itself is a strong word. It implies that the other party must do something. In this case, the payer should pay the money. By adding and positioning the word must to the expression, I am stressing on my conviction that I should insist on receiving the money. So adding the word must reinforces and validates my decision to insist on receiving the money. In such cases, adding the word must makes a difference to your statement, making it more assertive, that much stronger. So friends, I trust you enjoyed this particular capsule with a bit of a legal flavor.